Okay, so at this time, I would like to call this meeting to order. To start, I would like to let the public know that we started a little late. We were giving Searles Valley Minerals time to work through some issues to get online, but we now have everybody online, and we will go ahead and start. So if everybody would please follow me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, at this time we'll move to item number 3, public comments, or I'm sorry, roll call. So we'll do roll call next.
Chairman Heyman.
Present.
Vice Chair Ratora. Director Itmeyer.
Present.
Director Vallejo.
Present.
Director Peters.
Present.
Okay, at this time we'll move to item number 3, public comments. This time is reserved for the public to address the board about matters not on the agenda. No action will be taken on non-agenda items unless authorized by law. Comments are limited to 3 minutes per person. Caller, go ahead. Okay, caller, go ahead.
Hello, I'm here to speak about item 4. My name is Tyler Montoya, and I'm a third-generation employee and currently an operator at the Argus facility in Searles Valley Minerals.
Mr. Montoya,
Yes.
respectfully, this is public comments. I know this is a little confusing, but this is public comments for items not on the agenda. We're going to have a public hearing in a few moments for item number 4, and at that time, we'll have the public call back in, and that will be the opportunity to speak on regarding the Searles matter.
Okay, I understand.
Caller, go ahead.
Hello, this is Renee Westerlusk. I'm calling for two reasons. One, will the discussion of today's agenda item include a discussion on the separation of domestic water use for Trona? My question is there a separate pipeline or venue for Trona residents to receive water from the Indian Wells Valley that won't be interfered with should Searles Valley Mineral Corporation be forced to cease and desist pumping for their industrial use of the water? And then my second question is, will there be any discussion of the future availability in today's discussion for Searles Valley Mineral to purchase recycled water as outlined in section 5.3.2 wastewater recycling in the Indian Wells Valley GA engineers report.
Ms. Westerlusk, this is Keith Lemieux again, and I apologize for interrupting, but you probably didn't hear me say it a moment ago, but this is actually the public comment for items not on the agenda. I waited till I heard what your questions were, but they sound like they both relate to item number 4.
Okay.
And those topics will be discussed in that context, and you'll have an opportunity to call in during that public hearing.
Okay. Okay. Thank you for clarifying. Bye.
Okay, seeing no further public comment, we will move on to item number 4. Public hearing and possible orders on Searles Valley Minerals for failure to report and pay replenishment fees. Does not include domestic water service provided through Searles Domestic Water. At this time, I'd like to open the public hearing.
You want to start with a staff report, Mr. President?
I believe I was going to move to Keith Lemieux first, Jim, just for a brief introduction.
Okay, perfect. Thank you.
Okay, so we're doing something a little bit differently here today than we do normally at these meetings. This is we've got one item on the agenda, and this is what they call a quasi-adjudicatory proceeding. So the board is acting a little bit differently than it normally does, and our process is a little bit different than it normally is. You board members are being asked to make a determination, factual determination based on the information that you're presented from both staff and from Searles. You're to act impartially, and for that reason, we have not discussed this matter ahead of time. I'm here to answer any questions about the process that you might have. Mr. Markman is here representing staff, and we have also on the line Mr. Jeff Dunn, who's representing Searles. So the process is going to be as follows. First, Mr. Markman is going to be presenting the staff presentation. Next, representatives from Searles will be given the opportunity to be heard. We're not placing any time limit on any of these presentations, and we will be giving both staff and Searles the opportunity for rebuttal discussion. We invite the board to ask questions during this time to clarify things, but also at the end, I think there'll be another round of questions specifically from the board. After that, we will then invite the public to comment. Following public comment, we will close the public hearing, and then it will be time for board to and possible action. So that is the process, and with that, I turn it back to you, Mr. Chair.
Thank you, Mr. Lemieux. At this time, we'll now ask Jim Markman to present the staff report.
Thank you. Members of the board, this is going to be a fairly short staff report because we feel there's a very narrow subject matter in front of the board today, and it derives from the replenishment assessment and Searles' position with respect to the replenishment assessment. Let me say, since we already had some questions, I can answer right off the bat that other programs or negotiations for coping with the problem, the basin problem, Sigma problems, and Searles' position have never been foreclosed and are not foreclosed now. Those discussions are ongoing. So the other thing is we all know we're engaged in extensive litigation with pending motions which just occurred, motions which are coming up to be heard on May 20th. This, again, we don't connect what we're asking you to do today with those motions or the contents of the motions or the validity of the replenishment fee or any other things that are being litigated there. This is simply and narrowly a question of bill payment and what the board would like to do about non-payment. So to go over the situation, on August 21st, 2020, many months ago, the replenishment fee in question was adopted as $2,130 per acre foot by the board and was essentially frozen to be implemented only beginning with pumping, which occurred in 2021. So there was a period of time afforded for people to adjust to this, work it out, settle it, whatever, which in this case hasn't occurred yet. And there were two stated purposes, fundamentally purposes for collection of the money. And I want to say the reason that this fee is extremely important, which is also disclosed in the litigation, is this agency doesn't have overall ancillary sources of funds to implement this plan, even to protect its position in the litigation and to take care of the domestic wells that could be damaged while pumping continues to go on, lowering basin elevation. So I'm talking about Water Code Section 10730.2, which establishes the fee and what you can use it for. You don't have tax base. In addition to that, you're not selling water in addition to that. So basically, we're talking about protecting the fee, which is the only available funds, even for defending this lawsuit, let alone doing the other things it's intended to do, which are two things. One is to purchase water rights, supply a cash flow for the purchase of water rights, which is being explored and has been explored for months. And although it sounds a little bit abstract, it's not as far away as a lot of people might think. And the whole point was to get the water rights under control as early as possible, since with all these Sigma problems and the state water project being so short, 5% capacity this year, that the cost of the actual water rights, which would bring supplemental water and sustainability to this basin, is only going one way, and that's up. So that was always the major discussion in all the hearings. Can you defer it? You don't know exactly what it's going to be, but the calculations were well founded based on what those costs might be presently if we can secure those water rights. The second major purpose for this fee is to fund essentially what is expected to be damage to shallow, small wells in the basin, which has been documented by Stetson engineers, and there have been appraisal predictions of what the cost per well might be. And that also runs into several millions of dollars, the only source of which to fix those things will be this replenishment fee is prescribed in the water code. So there are reasons why it's crucial for these fees to be protected. And if they're charged, it's expected they'll be paid. So before I get on to the very specific facts and dates concerning Searles, one thing has to be made clear, crystal clear, because we expect questions. The order that's been prepared, should you actually issue a cease and desist pumping order, which is one of many options you'll be presented with, does exempt any water necessary to serve people served by that public utility in Trona. It's made absolutely couldn't be clearer in the order that we've drafted. I don't care how you state it. We are not going to issue an order that precludes Searles from causing to be pumped the water necessary to serve those residents. Those residents are also protected by the fact that they're served by a public utility, which is regulated by the Public Utility Commission. So I don't know what Searles' decisions would be should the board go in that direction today, but the responsibility of serving people when you're a public utility and they're in your service area, it's going to stay there, and we're not going to do anything to upset that by even purporting to apply what we're trying to do today to that part of the water pumped by Searles. So you can move into the public utility area to see what would happen. And this could happen regardless of our fee. If Searles stopped operating as indicated or cuts their operations way back as indicated in court declarations they filed last week, this week actually, last week, that still would not, whatever they do with their business doesn't relieve them from the responsibility as a public utility, or that particular public utility, from serving water to those people. And we don't know of another source of water other than what presently is being pumped out of the Indian Wells Valley groundwater basin. So that's an issue based on what has been submitted in court, one way or the other. But the action you may want to consider today is not going to cause that to cease. Okay, so on March 31st, 3 months after the beginning of responsibility to pay this fee when you pump water, nothing had been received from Searles by the Groundwater Authority, meaning they did not self-report the amount of their pumping or send a check together with it to pay the fee on that amount. So on that date, there was a notice provided to them by the general manager of the authority, which contained the language, contained in 10730.6 of the Water Code, noting that there was a delinquency, that penalties and interest were accruing, and that if they didn't respond positively, if Searles didn't respond, then there would be remedies considered by this board to effect that collection of the fees. And so that's where we are today. So nothing came in response to that changed the situation. So this hearing was timely noticed to occur at 10 a.m. today to consider, among other things, a potential cease and desist water production order to Searles, which would say cease and desist until you pay your bills and make them current. And that's one remedy that actually exists not only in the case law, but in Water Code Section 10730.6. So let me go over what the board has all kinds of options here. The only option that requires this public hearing is the potential cease and desist order ordering Searles not to pump water until it pays its fee current and makes it current. So the other remedies are there should the board want to pursue any or all of them. So going down the subsections in 10730.6 that are relevant, the subsection B talks about penalties and interest. So it's interest at the rate of 1% per month and a 10% penalty that continues to accrue. Section C reiterates the right of the sustainability agency to bring a lawsuit in a court having jurisdiction to collect any of these fees, delinquencies, and interest. And in doing so, the authority is granted the ability to do an attachment on property of the delinquent party, in this case Searles, and without posting a bond or an undertaking in that regard. So there is a remedy there, which is to file periodically, I guess, lawsuits that would go after the penalties and interest and attach the property that's available to you. In D, there's another remedy available to you, which is essentially, in the context of our JPA, any remedy available for collection of fees or taxes that is within the powers of a county, because the JPA has adopted the powers of the county in forming this JPA, this agency. Those could be pursued, and we could dive into that. It could mean things like taking all the penalties and interest and periodically creating tax liens and dropping them on the property. So, and then there's the fourth remedy, subsection E, which states, and let's just read this, as an additional remedy, a groundwater sustainability agency, after a public hearing, may order an owner or operator to cease extraction of groundwater until all delinquent fees are paid. And if you choose to do that, there's been an order prepared for that for you to consider today. If you choose to do that option, and then the Groundwater Sustainability Agency would have to give the owner certified mail not less than 15 days in advance of the public hearing. This was done, and the whole code section was sent to Searles. So what does that mean? It doesn't mean that if the board adopts that order today, to be honest and practical about it, if you did adopt that order, then we're not going to send people out to physically purport to be able to go on Searles property and turn off the water pumps or anything like that. That just means that we'd set sail on another court proceeding in the appropriate court to try to obtain that cease and desist order, to enforce that cease and desist order. So those are the options that are available to you today. Staff has prepared the order. As I said before, it's in the staff report. I think everyone interested has had an opportunity to look at it, including the Searles representatives. And with that, staff's recommendation is to consider all of these options, pick the one that you have that you think suits the situation. Staff did recommend you adopt Resolution 04-21 which would adopt the order directing Searles to cease and desist pumping until they bring current the money they owe under the replenishment fee. And again, I can't say it enough. Exempt from that is any water necessary to be pumped by Searles from the Indian Wells Valley and served to maintain the residential service to that public utility out in Trona. So with that, I'd be happy to answer any questions that the board may have at this time.
Thank you, Mr. Markman. So at this time, we'll come back to the board for any questions that you may have for Mr. Markman.
This is Jim Etnier from San Bernardino County. Jim, I suppose the board acts today and approves this. I know you say, well, no one will go out and just turn off the water right away. What sort of time frame would we be looking at? Would that mean, obviously would have to go to court, and there's always question marks. Are we talking where the court order would reasonably be expected in weeks, months, years?
Okay, I'll give you an educated guess. It's not going to be years to find out whether the court will enforce this order. Whether we do it in the context of, we have three cases directed against the agency challenging the plan. That might be one venue that maybe we can even agree to go to. I don't know. But it seems to me that on the face of it, we probably would have to consider filing another action in Kern County, and at that time try to do an expedited process to seek this order. We haven't thought that through, but I'm going to say weeks is too short and years is too long. I'm sure there would be some months involved in doing that, and if we obtain that order, I wouldn't be surprised if there were writs taken to the Court of Appeals. So this does set you out on another legal course that I'm going to say months is the guess I would make. So would you say that this sort of timing, would this be likely to occur and reach a decision faster than the legal proceedings that are already underway with Searles dealing with their water rights? Or would that be, because it seems like one way or another, when that's resolved, this would become moot. So which of those would be likely to be resolved first? Well, I think we would get a resolution on this narrow issue of whether the cease and desist order should be issued. It's actually the flip side of the issues that are being pursued. The relief is being pursued by Searles and another party to not have to pay this fee while they litigate the validity of it. We don't think they have the better part of the legal precedent on that, but that's not for me to argue before you today. So I think that's a narrow issue. If the remedy applies, would the court apply it? On the other hand, if the other lawsuit goes off in a way where it's going to be fully litigated on all of the allegations made in the 550 plus allegations, paragraphs of allegations that were contained in Mojave Pistachio's case, that's going to take a very, very long time to do. But we also think that case may be vulnerable to fatal demurs. So it's hard to say. But I would have to say that this is a question of remedies that we're talking about today that I think we can expressly get at a lot faster than litigating all of the issues outstanding in those two validation actions that attack the plan, the fees, and about every process that this board went through for the last 2 or 3 years. But it's still not, this kind of remedy is not around the corner. Even if we filed a lawsuit to collect the fees, penalties, and interest, I'm sure there would be robust defenses put up. So I'm not sure any of these remedies are going to go, well, I know any and all of them are going to be resisted, and so none of them are going to happen in a few days. And again, nothing's going to stop us in the meantime from being open to discussing a solution with Searles on the whole situation, which we have been working at for months.
One last thing on this line of questioning. Would you say then that suppose we went the route instead of rather than turn the water off, the groundwater authority filed a suit to get a court order to order payment and order a collection of the debt? Would that take longer than with its associated appeals than to get this order? Or is this like or would this be expedited because for some reason as opposed to some of the other remedies that you had talked about?
I don't think we're going to get to again, I'm expecting resistance whichever way we go, but if your remedy is only to collect, then that'll be resisted, and frankly, it's a lot easier for someone in Searles' position to think about resisting a lawsuit seeking to recover money, which is what this is all about. That's why we think that they're not going to get an injunction against us collecting money while they sue over whether the assessment as taxes or assessments are valid. But in any event, I think that the final outcome of this cease and desist order would probably be something that got everybody would be pretty determined to determine the outcome of that quickly. It's a remedy it's a heavy remedy, and it's been applied and sustained by the Court of Appeals in similar cases. So, but I'm not looking. I don't know. I'm not looking for any of these outcomes to happen. There are, whatever we do in Superior Court or wherever we do it, there's avenues on these kind of remedies going right up to the Court of Appeals and so forth. So when we come to the end of enforcing this, I think it'll be at least months, as I said, whichever direction you go.
Thank you.
Any other questions from other board members?
I don't have my questions until we hear from Searles.
Very good. Okay, at this time, we would like to invite Searles to make its presentation.
Chairman Heyman, Brunel Blanchard, and I want to thank you for working to keep this meeting on track and for this opportunity to respond to your notice dated April 19, 2021, threatening to shut off all water to Searles Valley Minerals. As you well know, forcing Searles to cease all water production in the basin will force Searles out of business immediately, a lose-lose proposition for all concerned. Now let's move to your misleading claim in the same notice. Your claim that the 217 acre-feet annually for direct and sole use by Searles Domestic Water Company for domestic purposes in the Toronto community is not in jeopardy of cessation. You're wrong on the facts and you're wrong on the law. As a practical matter, Searles has been producing water from wells in the basin since 1930. This water is transported through two pipelines that merge into one pipeline and then flows through a water treatment facility for distribution to Searles' facility using pipes and tanks owned by Searles. In other words, all water production equipment and infrastructure is owned by Searles Valley Minerals. Searles Domestic, or Searles Domestic Water Company, purchased available surplus water from Searles via a water purchase agreement between the two parties that originated in 1943. This contractual arrangement has been renewed continuously since then, and most recently in 2015. Searles is the sole source of water for Searles Domestic. Searles Domestic is overseen and regulated, as Mr. Markman noted, by the California Public Utilities Commission. The The Groundwater Authority, a local agency, notwithstanding the JPA, has no oversight powers or control over the CPUC, which is a California state agency. The private party agreement between Searles and Searles Domestic Water Company is not within the purview of the Groundwater Authority. In other words, the claim of exemption for Searles Domestic from actions taken against Searles is of no practical or legal significance. Now let's move to something you know or you should know. Searles is a component of the Department of Homeland Security's critical infrastructure, a federal agency. This is why Searles was allowed to operate with full staff throughout the ongoing COVID-19 pandemic while other California businesses were being shut down. As part of the Department of Homeland Security's critical infrastructure supply chain, Searles is the only U.S. company and one of only 3 companies in the world that produces an ingredient critical to making type 1 pharmaceutical glass used to make vaccine vials, including COVID-19 vaccine vials. Yet this board has called a special hearing today to shut down Searles' water supply, to shut down Searles, and to cut off our ability to support the COVID response effort nationally and globally, and disrupt a global supply chain critical for COVID-19 vaccine vials. I'll let you ponder the significance of that decision. Finally, I'll remind this board that it was a letter from the Department of Water Resources, a California department, that is responsible for reviewing your GSP. That letter was dated December 8, 2021, and it raised programmatic concerns about the groundwater sustainability plan the board submitted that year. Among the stated concerns was a specific concern about the disadvantaged communities of Trona. I quote DWR staff. Staff are concerned that implementation of the GSP may have unintended or unexpected negative impacts on the ability for domestic water users in Searles Valley to access safe, clean, and affordable drinking water supplies. Your proposal today to shut off Searles water will have the direct adverse impact the DWR is concerned about. This is also the concern expressed by Rep. Jay Obernolte in his letter to this board, dated May 4th, 2021, when he said your proposed action today to shut off Searles water, and I quote, should be avoided at all costs. Chairman Heyman and the board, I thank you for your time.
Thank you very much, Mr. Blanchard. Do we have any other presentation from Searles Valley Minerals?
Yes, this is Jeff Dunn, outside legal counsel, special counsel for Searles Valley Minerals. And first of all, thank you for your patience and consideration this morning. I'll keep my comments brief. What you've heard from Mr. Blanchard is a situation that is unprecedented in California. We are not aware of any situation like this where a public agency would take action to cut off the water supply to a company, particularly one who has relied on groundwater for well over almost now 100 years, if not longer, with water rights that members of this board have acknowledged in comments made in open session, recognized in other documents, and putting at risk the water supply of the Trona communities. There's never been anything like this. Also, there's never been a fee like this one that you're trying to impose upon Searles, one that is so high, one that is complete and absolute. It does not even acknowledge the existence of Searles water rights. I don't have to get into a discussion about the water rights. All I can say is that, as a general rule, first in time is sort of first in priority. Now, that's a general rule, but everyone would acknowledge that Searles has been relying upon this groundwater for a long time. And the action that you're being asked to by staff to consider is to end that water supply to Searles. Now, I know the members of this board are smart and sensible people. I don't have to explain to you that if you cut off the water supply to Searles, two things will happen. One is Searles will go out of business, and if it goes out of business, it will never be able to pay a replenishment assessment. And so the very action that you're considering taking today is completely the opposite of what you want to accomplish. The second point is, I'm sorry to say this so bluntly, but the board staff or whoever is telling you that if the Searles wells are not cut off, that won't cut off the supply to the domestic water company, those people could not be more wrong. If the Searles wells are cut off, those customers of the domestic water supply company will lose their water supply. We will take all action to protect them and to defend against that type of action. Now, you've heard from legal counsel this morning that you're already involved in 3 lawsuits, and now potentially by your action today could be creating a 4th lawsuit. Let me just share something with you that I've learned with over 30 years of experience representing public agencies in groundwater rights litigation. That is that courts are very sensitive to the fact that communities, particularly like the Toronto communities, are dependent upon a groundwater supply. Ultimately, we don't think that a court will ever allow for action that eliminates Searles as a business and also eliminates the water supply to the Toronto communities. Should we be forced to defend ourselves and defend our communities in that fashion, and we're ultimately successful, even partially successful, courts have recognized that we will be able to recover our attorney's fees and costs. And so I ask you to consider the costs that you're incurring in 3 cases, and perhaps a 4th case by action today, where you have to pay your own attorneys and potentially would have to pay the attorney's fees for Searles and potentially other people who are challenging your GSP. That type of exposure, financial exposure to the member agencies, is something that should not be taken lightly, and you should consider it. You don't have to take my word for it. When you go into confidential sessions with your attorneys, and you have exceptional legal counsel here, you can ask them, is there a probability that ultimately Searles, sooner or later, will be able to either successfully challenge in part or in whole the GSP, or even stop the effort to shut down its wells? And if they are successful, you can ask your attorneys, would a court consider awarding attorney's fees and costs to Searles? And you can get the answer straight from your attorneys. I would ask you not to do something that would make you the first in California to shut off a water supply to disadvantaged communities and to a business who has relied upon groundwater since at least the 1930s and much earlier. This board has acknowledged publicly the water rights claims that Searles have are worth consideration. We have put into the record evidence to show the importance that Searles place has in not just the local community, but even nationally and internationally in terms of the COVID relief pandemic effort. Finally, I would ask you to consider that this fee was imposed back in August, and here we are in May. Since August, the world has sort of continued to do what it does. But my point is, all of these disputes that we have are going to ultimately be resolved by the courts. The groundwater rights disputes, whether all or part of the GSP is going to be invalidated or found to be valid, all of that's going to work itself out, and it will. And I'm asking you to not take yet a further step to sort of shortcut the process that we have in place to sort of rationally and deliberately allow the courts to sort of do what they're supposed to do. This type of action, which is just putting a gun to the head of Searles and the communities that depend upon it, is unprecedented and it's unwarranted. There's time here, and there should be time here to continue to allow the courts in the process of settlement and resolution to work itself out. So I'm asking you not to take any action today, not to shut off the Searles wells, and not to impose any further fees until the courts can do what the courts are supposed to do and will do to resolve this. Thank you.
Thank you, Mr. Dunn. I'll bring it back to the board for any questions that they may have for Mr. Dunn or Mr. Blanchard.
Mr. Chair, it's John Vallejo.
Go ahead, Mr. Vallejo.
I'd like to know from Soils why they aren't paying the fee currently.
Mr. Vallejo, we are currently in litigation. As Mr. Junn pointed out, we have 3 different lawsuits, and that'll be determined. The legitimacy of the fee will be determined in that litigation, so I'm not going to discuss further the nature of that litigation.
I guess I'm just wondering, as a practical matter, for people on the street, laypersons, why Searles believes it shouldn't pay the fee. What's your position that a layperson would understand why you shouldn't pay the fee?
Let me try it again. I think I answered your question once. I'll answer it again. It is in litigation. We've pointed out the fee is unprecedented, exorbitant, and excessive, and is not related in any way to our water use. It's up to the attorneys and the court to decide it.
Okay, so you've given me a non-answer.
I've given you the answer you're going to get.
Okay. And I also heard that Searles has already, over the past 2 years, has made declarations in court that you're already losing money on an annual basis regardless of this fee. Is that correct?
If it's in the court record, you can research that yourself. I'm not going to speak about our current financial condition. We have presented information to the court that says, as a result of the earthquakes of 2019 and as a consequence of the recession created by the global pandemic, our finances are strained to the point of a negative net income. And I will not comment beyond that about our financial condition.
Okay. Another question, is Searles' refusal to pay the fee based on an argument that they have a pre-Navy water right that entitles them to pump some of the sustainable yield, and because they are entitled to pump some of the sustainable yield, that shouldn't be subject to a fee?
Mr. Vallejo, again, all of the nature of all the arguments are better handled by counsel, which we've retained Jeff Dunn. I can tell you, as a matter of fact, historical fact and record, Searles has priority pre-Navy water rights.
Okay, thank you. And has Searles taken any action to prove that water right against the Navy in court to date?
The Navy has taken action to demonstrate those rights in court, and counsel can speak to that more than I can.
No, I wasn't asking if the Navy has done anything. I was asking if Searles has taken action to prove its water right against the Navy in court.
Again, we have got 3 cases in court, and all of the legal arguments presented, I am not sure how they've been presented. I know that the court has been made aware, and all the interested parties have been made aware that Searles has priority pre-Navy water rights.
And I'm asking, have you brought the Navy into those lawsuits to prove your claim up against the Navy's claim? I'm not asking what your argument is. I'm just asking, have you brought your arguments to court against the Navy because your claim's against the Navy's right? That's my question.
I'm not aware of any actions we've taken in that regard that have been presented to the court. I haven't seen that latest filing.
Okay, because
I know there's also adjudication that was initiated against us by other parties, who I can't remember now, that included others. So I'm not aware of our response to all of those. That's why I've retained counsel to handle this.
Yeah, I mean, I'm not asking for legal arguments. I'm just asking for if you've taken certain actions to establish your claim. And the reason I'm asking...
I'm telling you, I've retained counsel to take actions on Searles' behalf. I do not micromanage their legal strategy or tactics.
I appreciate that, but I assume that they're taking direction from you about how to make your claims. So, I mean, that's a little It's another non-answer to say you've hired attorneys to do things for Searles, but Searles is in the driver's seat for what the attorneys are going to do. So it doesn't seem to be, avoiding the question is one thing, but completely refusing to answer is another thing. That's fine. I just want to make sure my understandings are correct, and maybe I can get them from other folks, staff on our end, who is more aware of the specifics of what Searles has actually done. My understanding is, at its heart, Searles is claiming a water right that is not subject to the replenishment fee because, in their opinion, their water right predates the Navy and therefore is part of the sustainable yield. But my understanding is that they haven't taken the Navy to court to prove up this water right. Mr. Markman, is that a correct understanding?
I think that the best way I could say it to be accurate is Searles has consistently raised the question of whether they have a prior and paramount right that preceded the Navy's date of reservation of the military reservation, and that gives them a priority. And at the same time, of course, I'm going to tell them for Jeff's sake, they also allege you cannot determine water rights. You can't determine the nature of the water rights of the Navy versus Searles. So the only final disposition of that would have to be done by a court. We are in the court with two cases that raise that as a very central part of their theme. The point that the Sustainability Agency is making is, look, we don't have jurisdiction over the Navy. You have a dispute over whether the Navy's rights essentially consume all of the safe yield together with the de minimis producers, which we think they do based on what they have told us factually about what their needs are. And they've said they aren't going to put a number on their reserve right unless they have to do so in court. So one of the positions, which is of no surprise to Searles or to Mojave Pistachio in both of those cases, is that we have no control over the Navy. We have no jurisdiction. You filed two actions, validation actions. You didn't bring the Navy in. You probably couldn't have because they have sovereign immunity, so you can't even get at the Navy and bind the Navy to any of these determinations in the context of this SGMA process, which is, I think, unfortunate for everybody, all parties under SGMA. So nobody's going to be able to do this in the present lawsuits without the Navy present, and that's going to be a point we're very soon going to raise before the court because we don't think this case, based on our assumption we can't control the Navy and they're going to essentially consume most of the safe yield, is the reason we made allocations. We did not make decisions on water rights because of that. We made allocations we thought were equitably based, and we have been negotiating with Searles and Mojave Pistachio about remedies and agreements which could be equitable in the end. But the Navy's not in the cases. The Navy, and without that, we don't think those cases can go anywhere meaningful because the Navy's still in the basin. The gorilla is in the room, ready to pump all the water they need. Well, we spar both before this board and we're sparring in court. So, yes, those defenses have been raised by Searles. No, we didn't try to adjudicate water rights. We're just dealing with a situation where we're not hiding from the fact the Navy can and possibly will consume all this water, make their own claims about the extent of their reserve rights. So we proceed with what's left, which isn't much, to allocate without a fee. We have allocated water without a fee in a certain sense between the ag pool, and we're allowing people to continue to produce and drop the basin down so long as they pay this fee so we can buy supplemental water and fix the shallow wells. That's what it's about. Thanks. So you have all these have been teed up in the case, John. It is true. Searles has consistently raised that position. It's not new. The problem is this agency didn't try to and has not adjudicated it, and the Navy's not in either case. Okay. So there we sit. There's another dilemma in this whole process amongst all these parties.
Right. Thanks. A couple more questions. Jim, Mr. Markman, are you aware of a declaration that I was referring to from Searles Valley? I believe it was Mr. Blanchard who actually signed it, that Searles is apparently losing approximately $10 million a year even before paying water fees. Is that something that...
Yes, I'm aware. I'm aware they filed that declaration.
Okay, I just want to make sure that it exists and it's not just something I'm mistaken about. Can you give us any more specifics about what Mr. Blanchard declared to the court about the viability of Searles currently?
Well, in general, the declaration talked about the specific present situation of Searles, really a cash flow issue, and how having to pay this fee would add to a deficit that's being incurred by them every month, and that they might have to make some changes in their operation, but they didn't talk about. He didn't say anything about we may have to go out of business, or we're on a tight timeline, or this will drive us out of business. He just concluded that all the position he's in plus what this cost would add to it could cause them to make structural changes in their operation. I think is the fairest way to put it. I think that's what he said.
Okay, I think that's for the board members in terms of where my questions are going. I'm just wondering if Searles is even a viable business moving forward, regardless of these water fees. If there's something else going on behind the scenes that makes this water valuable for them to sell later or something to that extent. But anyhow, yes, Thomas Kiefer, if we were to waive fees for everybody who otherwise we understand is required to pay fees, would this authority be a viable entity in terms of being able to pay for its costs moving forward?
No, absolutely not. Our basis is fees, whether it's the extraction fee or the replenishment fee, and the replenishment fee, as we heard earlier, has a specific purpose, and that is to allow us to bring in water to create a sustainable groundwater basin for the future.
Okay. I might have a couple more questions a little later, but
Mr. Vallejo, can I amplify that a little bit?
Yeah, sure.
In particular, well, let me clarify something first. There's been talk a couple times about 3 cases, and this would be a 4th case. The authority is not involved in 3 cases. There was a case filed by Mojave and a case filed by Searles. They were on the same subject matter. Those 2 cases were consolidated. They're essentially one case. That is currently the only case that's relevant to the subject matter that involves the authority. So in the event that we have to enforce an order, we don't know if we would be filing a 2nd case or simply filing something to expand the current case, but there will not be a 4th case or even a 3rd case. But speaking of defending the cases, you asked the question, how would we do financially without the fee? Bear in mind that another factor here is we need the fee in order to pay the cost to defend the case. So in the absence of the fee, I mean, one way to strangle us out of existence would be to not pay the fee while we litigate with them.
Okay, well, yeah, one more question. Mr. Hall, I believe you're involved with some of that litigation as well. Are you also familiar with that declaration? Do you have that handy?
Yes, I do. It was a paragraph 24 on page 7 provides, Searles has been operating, this is a direct quote, Searles has been operating at a net loss of $875,000 per month, approximately $10.5 million per year. In the next paragraph, quote, Searles is unable to access additional lines of financing from its current nor from other financial institutions. Searles has largely exhausted its current financial resources.
And that's all speaking to pre-fee costs?
This is pre-fee, and this is signed by Mr. Bernal. I would believe under oath is a declaration, although it doesn't say it above his signature, on April 26th of this year.
Okay, thank you. Mr. Chair, I might have some more questions, but I'll hand back this table for now.
Thank you, Mr. Vallejo. So this is Chairman Heyman. I have a question to Mr. Blanchard. So in the event that there is a cease to pump order, as the staff has stated, water to the domestic users of Searles Valley is not to be cut off. And so if water, the 217 acre feet, or let's say sufficient water to supply the domestic water users of Searles Valley is provided, is that water going to be provided to that domestic water company from Searles Valley?
Let me answer as directly as I tried to present it. If you shut off all water to Searles, you will shut off all water to Searles Domestic Water Company.
Okay, but that doesn't answer my question. My question is, we would not be shutting off all water to Searles Valley. There would be, and I'm not referring to Searles Valley Minerals, I'm referring to, say, Trona, or but the Searles Valley is what I'm referring to. But what I'm saying is, if there was a cease to pump, but there will be water, sufficient water for domestic water users provided, that's going to flow to Trona. You do your infrastructure details. Is that water going to be then provided from Searles Valley Minerals to the domestic water users?
Look, Mr. Heyman, that's a hypothetical.
No, it's
designed to run at a certain rate, 1,600, 2,000 GPM. It's got special valves in it to maintain positive pressure called clay valves all through the system. This trickle of water you imagine that'll come down there to somebody isn't going to happen. When you shut off the pumps, as you said you're threatening to do in this thing, you will shut off all water to Searles. You will drive Searles out of business. There will be no water provided by Searles to Searles Domestic Water Company, and Searles Domestic Water Company gets all of its water as surplus water that's made available by Searles and sold to the Searles Domestic Company through a separate water purchase agreement. And I just explained that in my opening comments. So you can't have it both ways. You shut down Searles water, you're going to shut down SDWC water.
Mr. Chairman, this is Jim Merkman.
Go ahead, Jim.
We are very much concerned about that. And I think that Steve Johnson might have something to say about that. I'm not sure, we're of course not sure about the engineering statement that was just made, but normally speaking, the Public Utilities Commission would presumably issue a certificate of convenience and necessity on the basis that the water to people who live there isn't dependent on the plant running. But it may be. I'm not saying it's not. So maybe Steve Johnson could speak to this. We are definitely concerned about the fact that we're not interested in issuing an order that, because of the physical situation, deprives these people of water to their homes. And we have talked about that. And so maybe Steve Johnson can respond to that a little bit, and what it would take for what's just been stated to be demonstrated to him one way or the other.
Chairman, if I may ask a sort of a related question, we're kind of forgetting there was a big earthquake out there where Searles shut down for a while. How did the domestic get service during that shutdown period of the earthquake?
I'm sorry, who's speaking?
This is Searles, sorry.
Well, that's a related question. So I leave that to engineers. I don't try to be an engineer. It's hard enough to do law. So, Steve, do you have some input on that?
Thank you, Jim, and thank you, Chairman Heyman. I have some. We don't know enough about the Searles operations. I mean, one of our tasks through the Recycled Water Program and study, considering potential coordination with Searles to use that water. We have to learn more about that system, but there's just not a lot of information out there about how the system operates. So I don't know if what is being presented is physically cannot serve the domestic customers, or a decision being made that they will not serve. I don't know. We don't know the difference to that. You're totally correct. The PUC does issue a certificate to operate. DDW, Department of Drinking Water, we understand all cities use a permit to operate that system, and all I can say in the big picture is that all my years, and it's right at 45 years in the water business in California, in Southern California, Western United States, I've never seen a case where there was a system. This isn't an unusual system, I'll grant that, but I've never seen a case where the operation of a industrial facility was the sole supply and the domestic customers were 100% reliant on the operation of that industrial facility for the domestic customers to receive water. I don't see personally, I don't have facts on this right now to present, but I don't see personally how you would get a PUC certificate to operate or a DDW permit if some kind of a operational problem with the industrial facility would cause domestic customers to be out of water. Their job was certify systems to operate for safe and reliable water supplies, and that doesn't sound like a safe and reliable water supply, if that helps.
Mr. Chairman, this is Mr. Dunn, legal counsel for Searles. May I be heard?
Yes, go ahead, Mr. Dunn.
Thank you. Normally, I would reserve comments for a further portion of the hearing, but the reason I asked to be heard right now is based on what you've just heard. The record before you shows you have no real understanding or knowledge to counter presented to you by Searles that if you cut off their water supply, it will cut off the Trona community supply. And I'm sorry to be so blunt, but you are engaged in something that is reckless and dangerous to the community, public health, safety, and welfare. And I make this extraordinary request that you stop this process now, based on what you've heard from your own engineer, the lack of your understanding about the serious consequences that can follow from this. You're ignoring what you're hearing from Searles repeatedly in terms of the consequences that will happen. And you have no effective counter evidence to that. I'm asking you to stop this now and withdraw this effort and allow the court process to proceed. And the record will reflect that we asked you to do this now. And should you go forward with this process, and should there be any harm or damage to Searles or the Trona communities, this moment in the record will be identified as putting you on notice of the potential liability that you will face.
Thank you, Mr. Dunn. So I have a question, I guess, for you or Mr. Blanchard. But so what is the minimum amount of water? You know your infrastructure. What is the minimum amount of water that needs to go through those pipes to be able to supply the domestic users of Trona?
Let me try this one more time, Chairman Heyman, and I do appreciate your patience. Searles Domestic gets any available surplus water that Searles has when it pumps. It pumps a massive system. It diverts the water to its facilities. It stores it in tanks all over the place. It has a designated tank where it puts water from its overall treatment. It only has one wastewater treatment system that's designed to handle massive volumes of water, the full pumping of 2 pipelines and 5 wells, and then it goes through there, and then it goes to a tank and made available to Searles as surplus water that they purchase. This is our system that's been in place since 43. It was approved by San Bernardino County originally. It's now overseen by the California Public Utilities Commission. They're fully aware of the nature of the arrangement, and they're supportive of it. And they approve it every time it comes up for review. There is no minimum amount. The amount that's made available is what is surplus from Searles' massive pumping. And I say massive, they're 2,800 acre-feet a year. And as a consequence, there is no small amount of water you can trickle through the system. The clay valves that are used to keep back pressure in the system to ensure the water is sanitary operate at 30 psi. And there's a series of them up and down the chain. So this idea, well, we can just open bottles of water and dump them in the pipeline and they'll flow down there just enough to be 217 acre-feet a year is a fantasy. And it's something that somebody has hypothetically come up with and has no idea of how a large system like this works?
Mr. Chair, can you ask the question again? Because I still didn't hear an answer.
I didn't either, and so my question is not about the 217 acre feet. I asked what is the minimum amount that could flow through the system to provide the domestic users of the domestic users. What would be the minimum amount of water that could flow through? Hang on. My second question is, and add on to that, is if that water is provided, is Soils going to provide that water to the domestic water users?
So there's two parts. Two parts. Okay, I'm going to make an estimate, but based on the flows and talking with my engineer yesterday on the same topic, we could probably the flows could be reduced by about 20% from our current level of pumping. So let's say 25% of my 2,800 feet is the amount my system can handle as the minimum flow, which is what you're requesting, the minimum flow. Okay? Now, your second question is, if the water, if I'm incorrect in restating it, you correct it for me. If all water is shut off to Searles, is Searles going to provide water to SDWC? Was that your question?
No, but it is a question, I guess, if you'd like to answer that one too. But the question is, if water is provided, if water is provided through the pipeline to Searles Valley Mineral on a limited basis, are you going to provide that water to the domestic water user? That's it. That's my only question.
Okay. If water is reduced to the minimum that I estimated for you, so I think my system will handle, I can do it to a level that's 20 to 25% below the current average pumping, then yes, I will fulfill all of my requirements under the CPUC requirements to Searles Domestic Water Company. I will provide water to them. Until you shut off my water, I will provide water to Searles Domestic Water Company.
Thank you, sir.
Mr. Chairman, I'd like to respond a little bit to some of this. Could be an interesting and fruitful hearing without all the threats and all the statements of outrage. Because, for example, I think we need to understand the water system. I think that I'd be reluctant to continue to recommend something that could take these people's homes and make them uninhabitable, because whatever the PUC did, it's intermixed essentially their whole future and their residence to the continuous operation of Searles at 75% of their present water capacity. That's just what I just heard. We're concerned with that. From bringing this remedy to you, if that's the case, that's the case, and we would have to rethink whether we'd recommend that remedy. So nobody's going to take an action foolishly that could create a public health issue. This is about someone not paying, and we're forgetting, this is about someone that doesn't pay their fee. Whether they want to litigate over it for 2 or 3 years or whatever, they don't pay their fee, and there's a body of law that says they need to pay the fee so the government can operate, so you can fix the walls, you can operate even to defend the case, and you can go look for water rights with that fee. In the end, if they prevail, they prevail. But we're talking about someone not paying their bill. And don't turn this around. This should not be turned around so it looks like the GA or the staff is trying to do something negative to the people who live out there. If the people who lived out there read that declaration that went into court, and they can't survive and live out there and get water without Searles continuing to operate, they have more to worry about than us, because we're not going to put them in that position. So I suggest on this particular option that we find out what we can find out from Mr. Stetson about if what was said was true. You got an explanation today by asking questions. We've never had anything submitted to us from an engineer's point of view in the last 10 days, or from Mr. Dunn or anybody else, explaining all this to us so it could be investigated. And if we concur, that's just the way it is, whether the PUC should have or shouldn't have approve this and continue to approve it, we're not interested in creating a problem with people using their own homes by not providing water to them. So I think that should be pursued. I don't know how cooperative Searles wants to be in providing information, but I'm sure there's some information that can be had from the Public Utilities Commission that might verify or not verify what was said. I'd be a lot more comfortable if we had the answer to that question, because nobody wants to waste the board's time. Nobody wants to waste time in court with a remedy that we go to the court and then we meet this engineering defense anyway. So I think we need to get the question either resolved, and if it is what it is, once it's resolved, and we can have our engineers look at it. If Searles was cooperative in that, that might, and they're correct, that might be the termination of this discussion going down this road from your staff. Because, again, we're not interested in pursuing a remedy for somebody not paying their bill by putting a bunch of people out of their homes. That's just not in our thinking.
So on that note, I guess another question to have on that line of questioning is, after the earthquake, I understand Searles shut down. But at some point before Searles reopened, was the domestic water supply being provided for the domestic users?
I'll answer that directly. There was a period of time when there was no water for Searles Domestic Water Company. The lines were ruptured by the earthquakes, as you know. They were pretty severe in both Ridgecrest and Trona. So the tanks ran out of water, and people ran out of water. We imported water and with the help of the California National Guard as far away as San Diego, California, and with the Offices of Emergency Services of California who were in here, as well as congressmen bringing in bottled water, non-potable and potable water to bridge the community, as well as resources from water districts around the state, particularly in Southern California, who came in to assist us in repairing the pipelines. But there was a period of time, I don't remember the exact number of hours, but it was close to 72, which no water was provided whatsoever.
Right, but my question was not that. It was whether or not before Searles Valley Minerals, the commercial industrial operation, reopened, did it provide water to the domestic users through the pipeline?
Good question. Okay, so let me try something. There's a lot of facilities out here, okay? We've got 55 square miles. We have an operation that recovers minerals and then 3 production facilities. So some of them were damaged more than others. So within that 72-hour period when the lines were repaired, water started flowing into Searles operations, large volumes of water, went through the water treatment facility. Then we had to repair the lines that fed the community, and that took additional time. But the water first came to Searles, and its operations that were able to continue to operating, which was about 2/3 of them, were up and running.
Okay,
so things happened coincident, and they happened in parallel. We got the lines repaired, Searles got water, it treated the water, the health department came out and certified the quality of the water, and then it was provided to the community.
And that was before or after the industrial operations of Searles began?
It was during.
Contemporaneous, okay. Another question I have is, are the filling of these tanks, can you describe why a flow rate is important to fill a tank that provides the domestic supply?
Say that again?
So my understanding of your system is you've described a tank that you fill up for the domestic supply. You've also said that there's a problem with having low flows for your pipeline system. It won't sustain a trickle, as you call it, of water for the domestic supply. But I'm wondering if you fill the pipeline with enough water to refill a tank and then turn that pipeline off, does that create the same sort of problems as a continuous low flow?
It would over time, because you're going to bleed off the internal pressure in the system that you have to maintain sanitary conditions. So Stetson can speak to this. You have to keep a positive pressure in a pipeline. Otherwise, you pull a vacuum and you're going to infiltrate impurities in the system, and it won't meet sanitary requirements. So a static pipeline, which this one is, which leaks, by the way, it has leaks, and we have teams that repair it constantly. It's two 28-mile pipelines that feed into one. That system has places that'll leak. We replace it with a lot of new pipe after the earthquake and contemporaneous with the repairs to the facility, but there are some pipes that go back 50 to 60 years that still leak, and we're repairing them constantly to maintain the positive pressure in the system. So the idea that you could say, that you have in your mind that you have pristine new pipes that are sitting there as essentially little tanks holding water is just not accurate. That system will leak water. And when it does, it'll go negative, and you will no longer have sanitary conditions.
And is Searles Valley willing to pay a fee on that lower minimum flows rate required that you mentioned? I think you said about 20 to 30% lower in order to ensure that...
I'm not going to negotiate what is in litigation in front of the courts right now, and that's what that question is. So I'm not going to answer that.
So is it Searles' position that you are going to refuse to pay the fee until there's a court order saying otherwise?
It's Searles' position that we're going to respect the legal process that is underway.
Chairman Heyman, I have a question along those lines. This was probably a question for legal counsel. I'm sure that it comes up all the time. Somebody or some entity has a fee levied on them that they don't want to pay. They want to protest that. They end up taking it to court. Is there a process? I mean, how are any case law established on how that's normally handled, what the requirements are of a company with regards to that fee up and until decided by a court?
Yes. Let me answer that. That's in litigation right now, but I don't think I'm saying anything controversial to tell you that there's a California constitutional provision and mountains of case law that talk about the fact that you're not relieved from your obligation to pay a fee or a tax even while you're contesting its validity. Because to allow somebody to do so, you have to pay under protest, essentially. Otherwise, a group of people as small as the group that are subject to this assessment in the Orleans Valley can essentially wipe out the government function by not paying the tax while they litigate, or the fee, while they litigate for a couple of years. So there's a particular case that came down in LA County a few years ago for the water replenishment district, was collecting a fee invalidly, actually, because they didn't comply with Prop 218. And this was contested, and there was a Superior Court judgment that said the fees were invalid, and that was appealed. During the appeal, a lot of cities, Downey, Cerritos, some very, very big taxpayers came in and said, we're not going to pay the fee because you've lost in the Superior Court, you're not going to win on appeal. And if we have to pay the fee, one of the cities said, we have to pay the fee, we actually can't serve water. We can't serve water to meet the water demand from our system. Same thing we're hearing here, and same thing you always hear if somebody doesn't want to pay a fee. And the Court of Appeal said, too bad, until there's a final judgment invalidating that fee, you have to pay it while you contest it. And that's from the California Court of Appeals on opining on a water replenishment fee, pretty much just like this one. So, you know, it's troublesome. Everybody understands how much of a burden everybody's trying to shoulder when you have a basin that's being pumped 4 times the safe yield, and you can't find anybody who wants to take at least part of the burden of making the basin sustainable by bringing in supplemental water, or at least helping to pay to repair wells that go down while you continue to drop the basin elevations and try to get a handle on this. But that's where we are. We understand why, and it's really all about money. So the other thing the court, you should realize, is that you can't usually get a court order that while you're contesting whether you owe money or whether you'll go out of business because you owe money, that in the interim you don't have to pay the money. So I'm sure we're going to hear, I don't want to start a debate with Jeff today over this. I'm sure we'll hear some responses to this. We've already made this position plain. But that's our view of the law. We don't think people can freeze out the authority while this case is going on so that the pumpers don't pay their fee. The case of Mojave Pistachio, they could be pumping 4,000 or 5,000 acre feet mining the basin while they contest the case and never have to pay a dime towards solving the problem. So we don't think that's where the law is.
Understood. And so just kind of along that same train of thought, if a company or an entity is not cooperative with that fee, or they're refusing to pay it, and that is kind of, as you said, undermining the governing body or the board that put that in place. And on top of that, we have the issue when they're saying we don't understand the engineering of the plant, how that water passes through to the end user. We do have a responsibility to provide that water to those domestic users. Is there any way, if and when the board decides to pursue this, I guess it's a temporary restraining order, could there be an addendum or a rider in there basically saying we're going to enforce this up and until the point that it becomes harmful or damaging to those domestic users?
I don't want the board to delegate that decision to the staff. I think the best way to handle this, in my view, with the hope that Searles cooperates, since they think they have this engineering position, I'm sure they would like to cooperate with Stetson so we can understand the engineering problem, because we do not want to recommend, and the board does not want to put someone out of their home. So I would suggest that if you want to continue to consider that particular remedy, that we can continue this hearing, probably to the date of a regular board meeting. I don't know whether June would be a good time to do that, the board meeting in June.
Oh, sorry, I didn't cut you off there. And I appreciate that. And that was just more of kind of a hypothetical question, but by the board making a decision one way or another today, that doesn't shut the water off, correct? It gives the opportunity to move forward on that at a later date if the board decides to. So I'm just thinking down the road, if and when that becomes a possibility, and hopefully
let's think about that together, implementing that, and assuming that we're going to find out some things from the PUC, maybe hopefully more from Searles itself. Even though we're litigating, that's a question I think they might be interested in giving us. The key to the answer is if you continue this hearing till the June meeting, it's a month, probably a little more than a month and 5 weeks. If you want to continue to pursue this remedy, I'm going to recommend you continue the hearing to continue to consider that at the regular meeting in June, by which time we would hopefully have an engineering answer to is there any practical way to apply this remedy without causing problems for those people in their domestic system. And I think that's very important to us. So that's what I'd suggest. If you don't want to continue to pursue this remedy, all these other remedies we described are still available to you, and you could direct staff to pursue any of those remedies that would seem to be effective. But so I think those are the two practical choices where we are right at this minute.
Understood. Thank you, sir.
Hey, Jim, this is Tim Ittmeyer. I just wanted to say that what you propose, sort not making a decision to and sort of continuing this until we get more answers. As the San Bernardino County representative on this board, the people of Trona are both my constituents as Supervisor Cook's alternate and his constituents as both a member of the Board of Supervisors and a member of the Groundwater Authority. And it sounds like the best answer everyone has is no one, at least on the Groundwater Authority side, no one is really sure what impact this order would have on the water. And I know that, a decision today wouldn't necessarily continue or wouldn't necessarily shut down the water right away, I know that I would be very uncomfortable and would not be willing to vote right now to shut off the water, especially without those answers. Setting aside some other questions I have, but I would certainly recommend that we continue this.
Can I make a suggestion?
Oh, go ahead.
If the mood of the board is to continue this, the issue we have is that Searles has made some allegations with no evidence to support them. And unfortunately, a lot of that evidence is only in the possession of Searles. So there needs to be some understanding that we can obtain whatever engineering reports or schematics or whatever is necessary. I mean, there's two different allegations here, and I want to separate them out. There's this suggestion if Searles goes out of business, then there'll be nobody to supply the water. That was one version of the argument. I'm not hearing a lot of interest in that argument today. But there's a second argument, which is if you tell us that we can't pump, the practical effect of not being able to pump is we can't put enough water through our system to supply the domestic water. We have to put at least a certain amount. And if that's the claim that you want staff to investigate, then I would suggest we come to an understanding now about how we are going to obtain those facts so that we have them in time to present them at the continued hearing, so that you guys can be convinced one way or the other about the truth of those assertions. So I guess my question is that information that Searles will voluntarily provide on a timely basis so that we could continue this hearing in 3 weeks, 4 weeks?
Mr. Chairman, this is Mr. Dunn, legal counsel for Searles. May I be heard?
Go ahead, Mr. Dunn.
Thank you. I take great issue with the representation that this board has not received evidence regarding Searles operations. You have received ample evidence, both before and during this hearing in the testimony of Mr. Blanchard. The record will show that that evidence is before you. It is completely improper to take this hearing, which is a threat to cut off our water supply, and now on the moment put Searles on the spot and demand, or excuse me, not demand, that's not the appropriate term, but make the request as legal counsel has just made. There are proper ways of obtaining information and exchanging information, and Searles will not, with a gun to its head, at this meeting, at this moment right now, respond to these types of requests. We have asked again and again that this water shutoff not take place. We've gone to court to ask that it not take place. The court will ultimately decide that, but you have the ability right now, today, based on the record before you, including the testimony of Mr. Blanchard and the testimony of your own engineer, Mr. Stetson, regarding the lack of knowledge to support staff's recommendation to cut off the water supply to Searles, and the hearing today to consider doing that. We ask you right now to make the decision not to cut off our water supply. No further discussion or negotiation or whatever is going to change the reality and the evidence that you've received. This is a delay tactic, candidly, to sort of salvage a fatally defective and frighteningly deficient staff report and recommendation, which would cut off the water supply to the Trona communities.
Mr. Jones, this is John Blair, and I think you misunderstood at least what I understand, Mr. Counsel, Mr. Ruben's statement there. We heard some evidence through testimony that Searles is unable to provide domestic water supply without nearly a full capacity pumping volume going through its pipes. I guess the question is the veracity of that claim. Is that evidence really, weighty or not? And what we're simply asking is, can Searles prove it with actual evidence given to our engineer? And if that's a hard thing to do, if that's something that Searles is unwilling to do, I think that speaks volumes. And so for you to accuse us of, moving quickly or excuse me, for delaying something when we're really just trying to be very deliberate and make sure that the facts as represented are actually confirmed and true. I think it's a distortion of what we're trying to do here. I think what we're trying to do is really wrap our head around the engineering issues with regard to the supply of water for domestic use that otherwise comes out of a tank once it gets through the pipes. And if Searles is unwilling to meet with us and our engineers and say, hey, this is our system, this is how it works, this is our concern about if you shut down the heavy flow or the large flow, and if you're unwilling to do that, I think that basically answers our question. And you can continue to litigate whether the fees are valid or not in court, while we simply just make sure that the claims made by Searles about the ability of the engineering to work or not are true. I don't see why it's so outrageous for us to want to make sure that the engineering can or can't handle this issue.
It's outrageous because you're making a decision and holding a hearing today without that information. Well, you know what you need to do. You need to cancel this hearing and start all over again and begin a process that's based on adequate information.
Mr. Dunn, I respectfully disagree that it's outrageous for us to continue the hearing to gather more evidence when you're saying that we don't have enough evidence.
Let me add something to Mr. Vallejo's statement. If somebody, this was mentioned in court last week, if somebody's going to say you're going to dispossess people and make their houses uninhabitable, when all we're trying to do is collect a debt, then clearly we proceeded in a way that could have made it clear we're not going to do this if it's going to have that health and safety impact on people. So now we're in the middle of a hearing. We get the chief operating officer of a company getting up, and I have no reason to doubt what he's saying, that this is the way it works. And in our case, it doesn't work because of the way the water moves through the system and so forth, and has to be under a certain amount of pressure. And so we have terrific engineers and Stetson engineers. They're not used to seeing PUC-approved systems that are essentially dependent on the existence of an industrial operation. Otherwise, there can't be water served to the persons who are in the service area. That's pretty unusual for me, too, and I've seen a few of these over the decades. So all we want to do, since this was brought up, could have been mailed in a week ago with documentation, could have said, go look at document such and such with the PUC, have your engineer look at that, and you'll see that that's what's going to happen, but that's not how it happened. But for Mr. Dunn to say in the middle of a hearing, it's improper not to start over, that we can't continue this for over a month to see if we find out if we're taking the board down a path they don't want to go, it's almost silly. It happens all the time in administrative hearings at the local level. So I'm trying to say, I won't recommend this if it can't be done without harming those people, but I want my engineer to verify that that's correct before we give a final position to the board. So if there's something strange about wanting to use a collection method that's obviously effective if you can judge it by the way Searles is reacting to it, but at the same time not wanting to do it if it harms other people in their residences by depriving them of water, I don't see what's irrational about that approach. If I was Searles, I think I'd be welcoming that. Fine, I've said what it is. I know that's what it is. They'll see that's what it is, and this remedy won't be pursued at that point.
Well, let me ask a question.
So it's nice to have things over right now today, but unfortunately, we didn't sue anybody.
Let me ask a question of Steve Johnson, because I want to make sure I understand. If we continue this hearing, I'm hearing that Searles won't cooperate with presenting information unless, I suppose, they get subpoenaed in the court action or something, I think is what Mr. Dunn was referring to. So if we assume Searles' non-cooperation, which would be consistent with how this has progressed until now, my question for Steve Johnson is, Steve, do you expect that we will have sufficient materials that are in the public record that we could develop in order to confirm this clay valve theory of we can only reduce our water by 20%, or I guess the system goes down? Are there records out there that you could obtain, or is this all in the possession of Searles?
I think the answer to that, if I may, Mr. Chairman, I think the answer to that is we don't have those records, and unless we can get that information from Searles, we have no way to get it. A couple of other things to mention here is that we do have pretty good relationships with the PUC and DDW. DDW assigns an engineer to a system like this. We have in the public record, we've gotten the permits out for the systems. It does show that the system shows on the DDW permit that it's served through a tank and a reservoir. So Director Vallejo's questions, I think, were good questions as to why flow rate becomes a big issue. If you're going to fill a tank and then serve customers, if you're higher flow rate, you just run your pipeline shorter time and fill your tank faster. Questions about a line being static for a period of time. There are systems all over the world, and all over the United States and California that have situations like that. Wells do that all the time. They shut them down all the time. So you have lines that need to be bled before you put them into your system. They do chlorine residuals before they serve it. So physically, what's being suggested that they cannot serve, physically cannot serve these customers, still, from my experience, in my opinion, doesn't make sense. But as you point out, I don't have that information. If we don't get cooperation or get the information from Searles, our next step would be to talk to the folks that we know at the PUC and DVW and get their opinion as to how the operation works and what is being suggested here today, that if the industrial operation doesn't operate, customers' taps will go dry, and see what their reaction to that is on those permits. And we have other sources that we can talk about offline to find out a little more information about Searles without going directly to Searles, but I'd better talk about that offline.
So I want to make it clear to the board that the situation is this, that documents have been provided under oath in court in relation to Searles' request that the court order they not pay the fee. Those documents, to my knowledge, do not include this information about clay valves and minimum amount of water flow, and we can only reduce by 20%. The first time I think that's ever been brought forward is today orally, and this is the first time we're hearing this. So what I'm hearing from our water resources manager is while we can't deny that because it's hard to, we don't have the information in our possession, there isn't an immediate logical reason that it makes sense, and it would be reasonable to, if you want to nail that down, it certainly would require further inquiry.
Can I jump in there real quick, Mr. Chairman?
Yes, go ahead.
So, yeah, I think we've kind of gone down a road that maybe some of the questions I asked earlier I didn't intend for us to go down. I mean, I want to make sure we have all the information available, but ultimately, looking at this order, this is the staff's recommendation that we're considering today is simply asking Searles Valley to pay the outstanding fees, and in the event that they refuse to pay, then and if they continue water production, then we're authorizing the authority to pursue legal actions at a future date. And it even says at the bottom of this order does not include production by Searles Domestic Water for domestic purposes. So I think, regardless of the engineering specifications any kind of technical details of how that water gets produced, I think the question really still boils down to, does this board want to put out an order ordering Searles to pay those fees? And if that doesn't happen, do we want to authorize the authority to pursue a legal course of action? And I think even with what I've heard today, that can still be fairly considered.
Thank you, Mr. Peters.
Mr. Chair, if I may.
Yes, go ahead.
Mr. Markman, to make sure I understand what's going on with the litigation that Searles continues to reference for their answers. Didn't they recently went into court asking for a restraining order against us, the Groundwater Authority, to collect the fees? Is that right?
Yes.
Can you kind of describe the litigation posture there, the history of what's happening to date and what's coming up next?
Sure. We were informed that there would be a temporary restraining orders sought by Searles and Mojave Pistachio, timely fashion. I won't talk about how much paper was filed, but it was immense and amazing. The court decided that, for whatever reasons, we don't have a written opinion, so I don't want to guess at what was the court's mind. This attempt was rejected. The court denied the motions, set a hearing for May 20th to consider a preliminary injunction that seeks to do the same thing, and that is essentially to stop the collection of the fees or their requirement to pay the fees, relieve them of the requirement to pay the fees, while the question of the validity of the fees and the whole lawsuit is pending. I've already described what I think the status of the law is on that,
yeah.
But part of the issue was, if it's just a question of paying your bill, or even going out of business if you pay the bill, that's not something that you get equitable relief for. What you could get equitable relief for is something terrible happens in a very short period of time that is irreparable injury. And so what I'm suggesting to this board is that get on solid footing as you feel very comfortable that issuing an order like this against Searles would not present a situation of potential irreparable injury to the people who are out there in the Trona community on that water service system. We've written an order that essentially says, if that's inevitable, if they stop their pumping, that would happen. We probably shouldn't pursue that order. I'd be way more comfortable if we knew all we can know. If Searles doesn't want to enlighten us with backup information about their systems and all the rest of the things they've alleged today, I mean, that's up to them. So eventually we'll get to that.
And did I hear correctly that they did not make these claims to the court with regard to allegations of irreparable injury? And again, like another way of saying that, they didn't claim there was going to be irreparable injury to the domestic water users if they had to pay the fee, or did they?
I think Mr. Dunn made a reference, a sentence or two reference to that the other people would be harmed.
But there was no declaration under oath that provided.
No, there was no declaration on that subject matter. But when it came up, he did say that was the case. But again, we received an explanation today on the record as to how it works from the CEO, but we don't have any data. I'm just trying to tell the board, it won't help you in court to proceed too rapidly on something like this where somebody can claim that there could be collateral damage and irreparable injury to these people in their homes.
I get that. When is the next the preliminary injunction hearing set for?
May 20th.
May 20th, so the end of this month. And if we continue this hearing, it'd likely be in the June hearing.
Yes.
I guess what I'm meaning for the board, what I'm meaning is, Searles is making a second run at trying to get out of having to pay the fees right now. They lost their first attempt in the temporary restraining order approach. They're now going for the next step, which is just all in the standard procedures of things, to get a preliminary injunction for the same thing. If they prevail on May 20th, that would essentially take care of this issue here. If they don't, we're back in the same boat. Perhaps in the meantime, between now and the June or whatever date we continue this hearing to, if we continue it, we can have Steve make good faith efforts, Mr. Johnson make good faith efforts to determine the validity of their engineering claims, and we can have some verified facts in front of us on that regard, and staff can either present the same recommendation or a modified recommendation based on the evidence that we have to prove whether or not the physical issues are legitimate or not.
That's exactly what I'm trying to suggest.
Right. So I don't know if there's other questions from the board that we want to hash out now, but I guess I'm ready to make a motion to continue this hearing to a later date, pending further discussion from our board members.
Okay, we have a motion from Director Vallejo.
Well, I guess I'm ready to make the motion, but I'd like to hear from the board members on that.
Because we still need to bring up public comment too, so.
Yeah. Which we could take out a continued hearing if we continue it.
Okay.
I'm sorry, Scott, I don't know if you can hear me, but my audio is gone all of a sudden.
We can hear you. Go ahead.
Okay. Sorry, I just want to let you know I can't hear what's going on right now. It's cutting in and out now. Give me just 1 second to try and fix this. Okay, I think I got you now.
Okay.
I missed the last part. The last thing I heard was Director Vallejo had mentioned making a motion, and then I lost all audio after that.
Yeah, Mr. Peters, my suggestion was I'm ready to make a motion to continue the hearing to be some date after the preliminary injunction hearing to allow, and would also allow our staff to verify or otherwise the engineering issues. And I'm ready to go there, but I wanted to hear from the board first about what process we wanted to take.
So just a thought on that, and maybe Mr. Bartman could correct me or provide some insight on this, but if we move forward on what the current staff's recommendation is, that gives Searles Valley the opportunity to pay the fee and move forward amicably or cooperatively. And before we were to ask a court to compel them to cease pumping if they didn't cooperate and did continue pumping, we could basically, the court would require them to cooperate and get all the facts before we shut off the water, but we'd have to know the implications to downstream domestic well users, I would imagine. So could we move forward on this today and hopefully we can foster some sense of cooperation, and if not, then we at least have the tools at our disposal to continue moving forward?
Well, again, I'm not even comfortable, and I have to tell you that I think creating collateral damage is about the only. I don't know that Searles would see it as helping them, but I think it might. And until I'm really comfortable and you're comfortable that that's just not going to happen, it's just an allegation, then this is just one of many remedies we can still sue them to recover the money, and we can attach assets. There's a lot of things you can do short of giving them a cease and desist order. The other thing I want to say, Phil, if you get the cease and desist order is something you issue, and then we'd have to, again, we'd have to go to court in another, either in the same form or in yet another lawsuit to enforce that, because they're not going to just stop pumping because you issued an order. They may pay. I have no indication they're going to pay. I didn't sense anything in their attitude today that they would consider paying. They want a court decision, which means they want to litigate it to the end, but they don't want to pay in the interim. So that's really what's at issue. I strongly feel that Mr. Vallejo is exactly hitting the right note, that there's no reason, that a month between now and the next board meeting, I know we'll know a lot more about the Searles system, whether they want to give us the information. If it's information helpful to them, putting aside this idea of the gun to the head because they might have to shut off their water, it's in their hands to do that. They could have sent in information like that already, technical information. So the fact they didn't creates doubt that didn't need to be here, if they're right. But I think between now and the next board meeting, if you want to then go forward with the rest of this process, after you heard what you can hear, then I definitely would support that. But at this point, I don't want to take a first step toward somebody being able to allege, well, we ignored the fact there might be collateral damage, because I don't think this board will ignore that possibility until we rule it out.
Neither am I. I just am concerned about, at another meeting, some new evidence gets presented and this becomes a vicious cycle, whereas if we take this initial step, maybe it can, really convey the board's direction or their thoughts, and then hopefully get this worked out before.
I think that what the board has said today, I think conveys your thoughts really well, and that is the fact that you've got we all have something in this valley to achieve, and that's sustainability. And there's very few people pump enough water to contribute financially to that. So we're really up against it. We don't have other sources of income. We have a lot of little wells that are going to get knocked out and no way to pay to repair them. And every person who owns one of those little wells is just as important as Searles, just as important as Mojave Pistachio. So it's a choice. There's threat and harm all the way around. So what I'm saying is I think it's better to get I'm not going to do this to you forever. I'm not a big continuance guy to begin with. But in this case, with that description of how the system works and the fact that we can't really Searles can't shut down if they can't pay or won't pay without harming these other people, we need to either rule that out or find or recommend to you another path to collect the money. That's how I feel about it.
Well, agreed, 100%. I don't want to see anybody get their water shut off ultimately or anything like that, but we have to have the tools at our disposal to get to that sustainability. So, considering everything I've heard, I'd be willing to second Director Vallejo's motion to continue this.
Well, I'll make a motion then, if Mr. Chair.
Before we get to that point, though, we do have a public hearing that's still going on, and I think it would be appropriate to take public comment now. If we adjourn the meeting, we'll consider whether we need to take it again at that point.
Okay, so let's hold on with our thoughts for a minute, and then I'll bring it to public comment, and then afterwards I'll bring it back to the board for final discussion. So at this time, we'd like to bring open up to public comment.
Bring it back to the board for final discussion.
Caller, go ahead.
Yes. So, am I on?
Yes, you are. Go ahead.
Okay, so I am Priscilla Benedum, and I oppose any efforts to cut off the water to Searles Valley Mineral. I was born in Trona, and for the past 16 years, I've worked for the Trona Senior Center. Prior to that, I worked for the company, so did many of my relatives, spanning through 3 generations. My roots in this community are buried deep. I'm also the current president of the Trona Joint Unified School District Governing Board. So I feel obligated to advocate for both the senior citizens and the students of Trona. I have spent countless hours trying to understand the current water situation. I understand that it is necessary to procure water for the future, but I cannot understand why an exorbitant fee is being charged without a reasonable solution. I cannot understand why the water fee is not being shared equally among all interested parties. I'm also confused how the Groundwater Authority plans on supplying water to Trona residents without supplying water to Searles Valley Minerals, because it is my understanding, and we've heard it today, that there is only one pipeline to bring water to Trona. It appears that the Groundwater Authority needs to research facts before they can make threats or promises. This is not a game of chicken to see who will flinch first. You are dealing with real people, elderly people with sweat equity in their community, and real students who are struggling to learn in an environment that has felt the effects of the pandemic and 2 major earthquakes. You are dealing with real concerns, real jobs, real economic issues, and real problems that will affect the lives of hundreds of people. Whether you realize it or not, in spite of your claims that the domestic water will not be affected by the replenishment fee, the domino effect will impact Trona, Ridgecrest, San Bernardino County, Marin County, the state of California, and far beyond. Decreases in mineral mining will be an economic nightmare. As I said before, I'm advocating for some 300 senior citizens who live on fixed incomes. And I'm advocating for the 259 students at Trona schools who will suffer if their education is interrupted yet again. So I'm asking you to make a responsible decision, go back to the table, find a real solution. I will continue to fight for our community until this issue is resolved fairly and equitably. I understand that you're considering tabling this, and I hope that you will do the right thing and vote against cutting off water to Searles Valley and let the legal process decide what is right. Thank you so much for your time.
Thank you, Priscilla. Caller, go ahead.
Hello, this is Renee Westerlust. I was listening to Mr. Markman's other options to collect the money that's due. Is it a reasonable option to go after a lien on the Searles Valley mineral property so that you can at least get the fees that you need? Or he also mentioned posting a bond. Can those be pursued in the meantime?
I don't have an answer for you, Renee. That's something that we could look into.
Thank you.
I have an answer for you, Renee. That's something that we could look at.
Caller, go ahead.
Yes, hello. My name is Shirley Kirkpatrick.
Go ahead.
Yeah, I'd like to mention a couple of things. Number one, when it comes to the sustainability board that is a non-elected people that was brought into this, I don't think Searles Valley needs to pay for water they already own. And there's certain things like you're not looking at the elephant in the room. First of all, we see that LA has been taking our water for several years. That's another fight. However, LA Water and Power is still digging wells. They've tried to dig one in Rose Valley. I don't know if that's still happening. And meanwhile, we're going after businesses like Searles Valley, and you probably don't even realize the fact that if you cut their water, Searles Valley employs a lot of people here in Ridgecrest. So where is these people in Ridgecrest going to go? So that takes away a lot of paying taxpayers here in Ridgecrest. I noticed that a few years back, Commander Bill Manowski, I can't say his name right, he had mentioned in 2018 that there's some wells like well 8 and 9 and 13, or I'm sorry, well 8, 9, and 13 were actually coming back. They came back about 48.3 feet. Well 9 has risen 6 feet. And so my point is that there's water there, and if LA's taking water, and we're having to come up with some sustainability plan. This plan is not legal, I don't believe, because it's been done by Jerry Brown in 2015. For everybody to come up with a sustainable plan. Meanwhile, LA continues to grow and look for water elsewhere. Thousands of gallons of water are dumped into the ocean to save some smelt fish. Meanwhile, we're going to destroy crops and businesses in Searles Valley because of a sustainable plan. Well, it's just not sustainable, and that's my opinion.
Thank you, caller.
Thank you.
Caller, go ahead.
Good morning. My name is Regina Troglin. I'm a resident of Trona in complete opposition to the possibility of this board shutting down SVM's production because of this replenishment fee. The fact that this board is having this vote at all when there is a pending litigation on this very matter is deeply disturbing. I don't work for SVM. I'm just a resident here in Trona. It's frustrating to hear the words out of y'all's mouths that residents won't get impacted. It's in your very own statements to the public. When you say those things, do you even really believe them? Because in just an hour of minor research on my own into this very matter, I found no less than 10 different government sources which confirmed what I already knew. If SVM cannot pump water, there is no water in Trona. You see, your ignorance to that fact is ludicrous, and your statements to Trona residents won't be impacted is a lie, and you know that. Searles Domestic Water Company doesn't own the wells. They don't own that pipeline. They own only one of the 4 towers in Trona, and they don't own the water treatment facility. So please tell me how we get water if SVM isn't pumping and bringing it here for their commercial purposes. since the agreement between both SVM and Cyril's Domestic has been that the domestic water provided to residents is surplus of what SVM uses from that basin which you now control. And that agreement, as you know, started in about 1943, which is approximately 20 years prior to Ridgecrest becoming a town. We only get surplus from SVM, and without SVM, we have no drinking water. The fact that you would threaten people's livelihoods, jobs, and homes is beyond me. This year has been hard enough, and now you want to force the second largest employer in the area out of business for what? Because you can't seem to manage finances appropriately. Trust me, I've been paying attention, and what I've seen is this board is using SVM as a cash cow, while others get to skate through without paying their fair share. It's angering because when Toronto residents sent in protest letters against this fee, we were told by members of this very board that our voices didn't count because we do not physically sit on the basin. Well, we do count. Our town has been using water and moving it into our valley since before 1930. SVM and its predecessors made this area what it is, and without them, we all go down, not just Trona. I get that the basin is overdrafted, and there's many things that need to be paid for. But to force this issue now, when you know that May 20th is the next court date, is absolutely ridiculous. This is nothing more than additional posturing and showboating to make SVM look like the bad guys. While it's not working because no one here is buying what you're selling. While residents here might not have a voice in protest, the majority of our workers at these plants do not live here in Trona. They live in areas where they can impact the votes for you on the boards and the councils which you currently sit on. So I'll ask you again, just like everybody else has, if SVM isn't in operation or isn't able to pump water from the basin, no matter what you guys say, how does Trona actually get its water? Thank you so much for your time, and I urge you to reconsider this matter.
Thank you, Regina. Caller, go ahead. Go ahead, caller.
Committee members, thank you for taking the time to hear me out. My name is Ray Becker. I've worked for the company for about 34 years, and I just wanted to share my perspective on this imposed fee or tax. It's my strong opinion that the local economies in both Ridgecrest and Trona would be significantly impacted. And in the case of Trona, more specifically, the economy would be devastated without the hundreds of good-paying jobs that Cerro Valley Minerals provides for its employees. If any of these jobs would be lost as a result of such a tax, it would seem like such an unnecessary impact to both communities and the citizens of which make up these two small towns. Understanding the need to preserve water and do what we can do reasonably to regain basin levels is easily understandable and something I think most people can get their minds wrapped around. What's not easily understandable by most of us is what this fee will actually do to add one drop of water to the basin, other than some vague description of importing water from some other location. While it's most likely the case, the case is that it would require some capital to regain basin levels. I don't think the authority has done a very good job to clearly define this and articulate that to the community. And to impose such an exorbitant fee on one specific company would represent such a threat to the communities. I don't think it's worth pursuing at this time. That's all I have to say.
Thank you, Mr. Becker. Go ahead, caller.
Hello, my name is Tyler Montoya, and I'm a third-generation employee and currently an operator in the Argus facility in Cerro Valley Minerals, and I'm here in opposition to today's action. My grandfather is buried next to my grandmother in the cemetery that borders our property line, along with the other parents and grandparents of my coworkers. This is important to me because it is a daily reminder of my heritage and is a cherished talking point that I enjoy sharing along with the other people I work with who have the same pride in our community and connection with our surroundings. I feel it is important for those who are taking the time to listen to me today because it provides insight to the demographic of Searles Valley Mineral employees. We are not a huge corporation spread all over America or a sea of faceless bodies that you cannot make out on TV. We are the people that inhabit Trona and the surrounding area. Some of our spouses, brothers, sisters, children work at the post office, the grocery stores, and the hospitals that help support the community that has slowly formed around this facility for the past 100 years. Some of us, such as myself, are a single-income household supporting young children and spouses who have had to stay at home during this pandemic to keep our families and communities safe, relying solely on the steady income and job security that Searles Valley Minerals has provided for so long. What the Indian Wells Valley Groundwater Authority is pursuing will directly put myself, my family, and countless of my coworkers and friends in desperate and, I fear, dire need or hardship. This company has committed to ensuring American manufacturing jobs that are rare in this area, I might add, not only after the devastating earthquake, but also through this global pandemic. I have nearly a decade of firsthand experience, but a lifetime of family history that can prove Searles Valley Minerals consistently seeks to improve on what we do and utilizes every resource we have responsibly and with care. We are not gross wasters or claim to have unlimited resources, but a company of people who cherish what we have available and plan on using what we have for long-lasting sustainability. As a taxpayer, I would hope and ask that the council will take the time to learn about the issues before getting to this point. I appreciate the time you have taken to listen to my story, and I'm grateful to speak on behalf of such a large amount of my coworkers and friends.
Thank you, Mr. Montoya. Okay, seeing no further public comment, we're going to come back to the board for discussion. So where do we want to go from here?
Mr. Chair, I'd like to make a motion to continue this hearing, and if it's acceptable to everybody else, to be added on to our next regularly scheduled meeting. And as part of that motion, I'd like to direct staff to conduct an investigation into the claims with regard to the engineering issues alleged by Searles if they don't maintain most of their flow through the pipelines. And at that point in time, we can hear back from staff on whether or not Searles was successful or unsuccessful with their preliminary injunction request, and we'll learn if Searles was forthright with regard to giving us facts and evidence regarding their claims of engineering issues, and we can make a better informed decision at that point in time and close the public hearing at the after the continuance is taken up.
Okay. So, can we get some clarity? Hang on just a second, everybody. Keith, Lemieux, go ahead.
Director Vallejo, I want some clarity on the motion. You said the next regular meeting. That next regular meeting would be a week from today. I assume you meant the one in June. Okay.
June, correct.
So the record should give you the time and date of that meeting, which is, I think it's 10 a.m. on June 9th.
So
second Wednesday.
Yeah, and I guess the question for our board is, do we want to handle our regular meeting business first or this hearing?
So this is Chairman Heumann. I think I'd like to hear from Steve Johnson on just a rough estimate of time that he would require to gather the data and review it.
Thank you, Chairman Heumann. Considering whether we're going to get any information from Searles, which we don't know, so if we assume we're not going to get any information from Searles, it shouldn't take that long, a few days, a week maybe, to research what we can research with PUC and DDW through the engineers of record there, the assigned engineers to the system, and their existing permits to serve. So that should not take very long. On the question of what we get from Searles, what it is and how long it takes to go through that, that's a hard one to answer, but if we got all of the information we need, it wouldn't take long to figure out whether or not
there are significant or major issues with trying to operate the water system without the industrial system running. It should not take very long if we get the information.
Okay, so do you feel the June meeting would be reasonable?
I think it is, yes. For what we're talking about doing, yes.
Okay, I have no further questions.
And if I may, I just want to add on one more direction to staff there in my motion. Based on the declaration that was filed in the litigation regarding Searles' current cash flow over the past few years being, as far as I can tell, significantly negative, if staff can research what is required for the domestic supply if Searles is no longer in industrial operation, I think that would be helpful to know as well, or could be helpful to know.
Chairman Haynes, I'll second Director Vallejo's motion.
Okay, we have a motion and a second.
Chairman Hayman,
Aye.
Vice Chair Rotora, Director Itmeyer,
Aye.
Director Vallejo,
Aye.
Director Peters.
Aye.
Okay, motion carries. So at this time, we'll move to closing comments from the board.
Mr. Chair, I'll save my closing comments on this issue until the hearing's taken back up.
Very good. Anyone else? Okay, hearing no closing comments, this meeting will be adjourned, and then we will have a continuation of this hearing on our April,
what was the date?
The public hearing will continue to June 9th at 10 a.m.
At 10 a.m.? Okay. And just so everybody's clear, it's going to be a part of our regular scheduled meeting. Okay. Okay, this meeting is adjourned.